Okay, so welcome to another one of the School of International Studies guest lectures. This week we have another GreenDeal-NET lecture. GreenDeal-NET is a Jean Monnet research network that the university, well, the School of International Studies is involved with alongside a number of other universities, including the University of Eastern Finland, which is one of the affiliations of today's speaker, Professor Annalisa Savaresi, who is from Eastern Finland University and also the University of Stirling. And Annalisa is a very famous expert in international and European environmental law, a long-time commentator on various aspects of climate change negotiations at the international level, benefit sharing, climate litigation, energy communities, and of course, forestry regulation, which she'll be speaking to us about today. So without further ado, I will give the floor to Annalisa.
Thank you. Thank you very much, Luisa. It's a pleasure to be here. I was actually recounting, I came to Trento so many years ago as a PhD student, as a visitor. So that's been a while and it's nice to be back. It's also a pleasure to talk to you about this theme. Since very many doctoral students are in the room, I should probably mention that I wrote my PhD on a related topic a few years ago now. And I very well remember going to my first academic conference with some of the leading experts in my field and going up to them and saying, I'm writing my dissertation about land uses and emissions from the land sector. And they said, why? Nobody does that. These people spend hours talking about the definition of a tree. It's very boring for lawyers. So, okay, I'll take the challenge. And here I am, years later, still talking about related themes. So it's not bad to start up your career doing something nobody else does. So this is the first takeaway, I guess, from my talk today. But more seriously, this is an area where there is a lot of technicalities and the interplay with natural sciences is really real. So bear with me as I run you through what is rather complex subject matter, and feel free to ask questions because the point of me being here is exactly that, to make it accessible and intelligible to you all. And of course, feel free to ask questions. And this applies also to those of you online. I'll try and answer the questions in the chat, but I'll do that in the end because that will otherwise be quite challenging for me to try and follow the chat, as well as looking at the people in the room. So, seeing the forest for the trees, what am I gonna talk about? There is a number of things that we could be covering today, but I thought I'd try and keep it simple. So I will say a few words of introductions on emissions from land uses and what they are, assuming that many of you may know this, but perhaps not all of you, and then talk about how this subject matter is being addressed in international law and finally in EU law. So lots of ground to cover. First things first, what are emissions from land uses? Emissions from land uses are the greenhouse gas emissions that come from a variety of activities that are associated with the use of land, agriculture, forestry mainly, but also specific activities that are normally, as a matter of course, performed in the course of land management. We've known that these activities emit some greenhouse gases for quite some time. They are very diverse though, as you can see from the images on the picture here behind me, which means that measuring these emissions compared with other greenhouse gas emissions is different and perhaps, as we will see, more complex. You have here, and I hope you can see clearly enough, a diagram from the latest IPCC report, the Intergovernmental Panel on Climate Change, recently released its latest assessment of global emissions. And in this diagram, you can see clearly that emissions from land uses are basically constant. They are not reducing. They are the ones in the top, but different gases come from the land uses. So we have methane, for example, that is also associated with land uses. And the takeaway from this diagram for you today is that these emissions are constant. They're not reducing. So why should we do something about this? They are a relatively small fraction of global emissions from land uses. We know for a fact that the bulk of emissions come from other sectors, especially industry and energy production. Well, the Paris Agreement, as many of you may know already, requires parties to achieve a balance between emissions by sources and removals by sinks by the middle of the century. And this balance requires that we reduce emissions in all sectors, including the land sector. Also, as we will see today, the land sector is particularly important because of the potential to carry out nature-based solutions. What are these? You can see this in this other diagram that I put on the slides for you. And it's a very small but important diagram that you see here at the bottom. What does this diagram tell us? It basically tells us that to get to net zero, as the Paris Agreement requires the parties to do, we really need to compensate the emissions that we cannot reduce by means, amongst others, of removals, which is what the land sector in principle can do. Therefore, this sector is more important than ever. The Paris Agreement has changed the role of this sector compared with the past, giving it greater importance from the perspective of achieving climate neutrality. But it is not easy for a number of reasons. And there's lots of literature on this. You will see that I have highlighted some papers in my slides. But in a nutshell, there is a specificities in this sector that are associated with non-permanence and leakage of removals. What does that mean? It means that when you, for example, store carbon in a forest, if the forest goes up in flames, all the carbon stored in it is dispersed back into the atmosphere. There is also the question of perverse outcomes associated, for example, with the fact that if I impose, for example, a moratorium on logging in Europe and no forests are being harvested here, the wood we need we get from somewhere else. So we're just displacing the logging rather than abating it for real. So leakage, incidentally, happens in other sectors. It's not only about the land sector. Nevertheless, there has been already ample evidence of perverse outcomes associated with adoption of policies that were not global in nature, and as a result ended up simply shifting the emissions geographically rather than actually reducing emissions globally. Beyond these practicalities, there are methodological specificities associated with measuring the emissions that we saw in the slide earlier. As you may appreciate, it's easier to regulate a polluter that is already subject to a lot of obligations concerning various pollutants. An industry, for example, it's very easy to know what they do because they are heavily regulated normally. So we know exactly what kind of pollutants they emit. When we are talking about farms, we don't have the same system. I mean, some industrial farms are similar to industries, and those are the easy ones. But when we're talking about small producers or small scale forestry, for example, it's very difficult, as we will see later in relation to Finland, to find out what collectively they are doing in terms of emissions, amongst others. It's also fair to say that because historically there was less focus on this sector, The science was not as developed in terms of grappling with the specificities of emissions in this sector. And this has ended up causing a great deal of scientific uncertainty that has resulted in fuzziness over the rules and the policies that have been adopted over the years in this sector, as we will see. The final point that may not surprise many of you is the controversial nature of this sector. It's very hard to regulate emissions in this sector because of the intersection with the food and sector, and in general, the sensitivities, the political sensitivities associated with anything to do with land governance. As you may know, the European Union, for example, even the European Union that has had for many years policy and governance tools in this area is very much on the edge when we are talking about farmers' subsidies. So we are here touching an area that is really controversial. And for that reason, again, states have for a long time shied away from regulating emissions from this sector. Now, I hope you're all following me by now. Very good. If you have any questions, ask along. But where did the rules start here? What kind of obligations do states have in this area, if any? It's fair to say that this is an area where international obligations came first. So we started to develop rules at the international level that then trickled down to the regional and national level. And it's important to remind ourselves what the UNFCCC, the United Nations Framework Convention on Climate Change, says about emissions from land uses. What the convention says is quite simple. It says all parties shall, amongst others, control, reduce, or prevent emissions in all sectors, which clearly includes the land sector. All parties shall also promote sustainable management, conservation, and enhancement of sinks and reservoirs, which is, amongst others, forests and other terrestrial ecosystems. So there are some general obligations here in the convention that was adopted in 1992 already concerning this sector. So why has the practical implementation of these general obligations been fairly slow? Over the years, the parties to the climate treaties have done a number of things to make these obligations real. And they have divided up the sector in three big governance, if you like, packages. The one is the one called LULUCF, which we will focus mostly on today, and concerns land use change and forestry activities. The second one is agriculture, and the third one is what is called RED Plus and concerns reducing emissions from deforestation in developing countries as a shorthand. So three different areas with different rules were developed over the years, and it's fair to say the state's obligations under these three pillars were less stringent or different in any way, in any case, depending on the moment in history at which we are looking at. In order to understand what happened to LULUCF, it's also important to understand that under the Kyoto Protocol, developed country parties could reduce emissions in this sector, but this was an option. They didn't have to reduce their emissions in this sector. They could pick and choose which sector of their economy in which to target their emissions reductions. And as a matter of history, it ends up that most states didn't do that. They prefer to leave the land sector alone for the reasons I mentioned earlier, and to focus on other sectors like industry and energy generation. One thing that the parties, developed country parties, had to do, though, under the Kyoto Protocol was to report emissions in the LULUCF sector according to standardized templates. So we have data, and the way we have gathered data in this sector is pursuant to the rules that were developed under the Kyoto Protocol. This is only for developed countries, though. This was a matter of legal obligation only for developed countries. What did the Paris Agreement do? I'm sure that, hopefully, I hope most of you in this room know that the Paris Agreement was a great leveler of parties' obligations in many respects, if not all. And what the Paris Agreement did was to basically import the rules under the UNFCCC into the architecture that was developed under the pre-existing treaties. Now, what is interesting for us to note is that parties should strive under the Paris Agreement to include all sectors into their nationally determined contributions. So this is not an obligation, but all parties should really do this, because as we know, under the Paris Agreement, in order to get to net zero, all sectors need to contribute, and the land sector is particularly important to get to net zero. So this is a very short summary of something that could have taken a long time to explain. And here's a paper that Lucia Perugini and I have written a couple of years ago, where we summarize the status quo under the Paris Agreement and the climate treaties. So now I want to zoom into the EU picture, because I think this is where things really get interesting, and especially from a perspective of GreenDeal-NET, this is an area where a lot of action is taking place. The land use sector in the European Union is not dissimilar to the first diagram that you saw, in the sense that emissions in this sector have remained more or less constant since the start of reporting. As a developed countries group, the European Union was subject to Kyoto Protocol reporting rules, so we have data going back to the 1990s on this sector. What is interesting for us to know is that because emissions in other sectors of the European economy have reduced, agriculture has become the second largest sector in terms of emissions in Europe. So comparatively, its importance has grown since the beginning of the climate regime. What is also interesting for us to know is that the LULUCF sector, especially the forest sector within LULUCF, is a great sink of emissions. So the sector is not producing emissions, but is actually reducing emissions, compensating emissions taking place in other sectors, which is exactly what we want with the Paris Agreement. We want the forest sector to absorb carbon and therefore mitigate emissions that we can't reduce. However, when you start scratching the surface, you discover that the picture is not as rosy as it might seem. First of all, the forest stock in Europe is decaying, it's getting old and storing less carbon. The situation is in fact more dire than this diagram suggests, as we would see in a minute, for a number of reasons, including climate change itself. The forest sector is not storing as much carbon as it had been hoped. Another thing that is important for us to know is that the assumptions upon which, as we will see, the EU has based its climate policy and governance arrangements are based on the premise that this sector will really play an important role in getting to net zero. So this is an important assumption, because if our trajectory to reduce emissions is based on an assumption that the forest sector will play a significant part, if the forest sector starts decaying and starts sequestering less carbon, we have a problem. And this is already happening in Finland, as we will see later. So what rules are there in order to make this happen, in order to keep our forests in Europe standing, in order to reduce emissions from agriculture. We don't have one policy tool, we have a number of instruments that intersect with each other. And here I give credit to my partner in crime, Lucia Perugini, for designing this diagram that I've been showing for years now. I know the cow is fantastic. When we are talking about agriculture, we're talking about a different sector. When we're talking about LULUCF, the LULUCF regulation that was adopted for the first time in 2018 only covers, as you can see, some activities that fall within the scope of agriculture, agroforestry largely, but for the rest, agriculture is regulated under a separate instrument. More importantly, there is overlaps with the Renewables Directive, because the Renewables Directive has always dealt with the matter of biomass, which is also an activity that generates emission. And finally, of course, in the background of all this is the common agricultural policy. The common agricultural policy is not a tool that has been designed with climate change in mind, yet over the years, there has been greater pressure to take into account the issue of climate change within the subsidy system for farmers in Europe. So what was in the EU regulation 2018/841, also known as LULUCF regulation? Again, this could take a very long time, but you get a very short story. What the LULUCF regulation did was to introduce new accounting rules for the LULUCF sector. I told you already that under the Kyoto Protocol, the EU as a developed country party had specific obligations, and the reporting and accounting had been done in line with that in Europe. So it's not that there was no accounting up until the adoption of the LULUCF regulation, but in preparation for the 2020-2030 decade of commitments and reductions, the European Union decided to upgrade its rules. The upgrade of these rules was also necessary in order to do a number of things that the EU wanted to do in this sector for the first time in the current decade. And in order to enable this, first of all, we needed to have better data, more granular data than we had before, but also we needed to have national forestry accounting plans, which were a new instrument that was for the first time introduced by the LULUCF regulation. The European Union, in other words, wanted to know more of member states, of what they were doing in their forest sector, not only in terms of emissions, but also in terms of planned activities. At that point in time, which feels very remote already, the EU decided also to introduce the so-called no debit rule. This means that if the sector generated debit or credits, those would contribute to the achievement of the targets of the European Union for 2030. This may sound obvious to you, but it wasn't so in the 2010-2020 decade. This was the first time the European Union decided that this sector would contribute, or not, depending on how it would perform, to achieving its target. The contribution of this sector to the 2030 target was, however, capped. And this is a relic from the Kyoto Protocol. There was always a desire to keep the contribution of this sector low, because priority was given to other emission-intensive industries, rather than mitigating emissions in the land sector that we know in Europe was relatively less important, at least in the past. This is another diagram that Lucia designed, and I will not try to walk you through the intricacies of the flexibilities introduced by the LULUCF regulation. What is important for you to understand is that this was an effort to bring the LULUCF sector truly within the architecture that the European Union had created for climate governance, which means that the credits and debits generated by this sector had to become fungible with those created under the effort sharing directive or regulation, depending on the moment in history when we're talking about here. So here we have really an effort to make LULUCF really integrated into the system that the European Union has created of credits and debits in order to incentivize member states really to do the right thing. If you want to see the half full glass picture, or to engage in creative accounting if you listen to some NGOs and detractors of the flexibility mechanisms that the European Union has created. It's fair to say that from moment one, this was controversial, and it's fair to say that we have had limited experience with this system for the reasons that I'm going to explain to you now. Nevertheless, this is what the LULUCF regulation did in 2018. And again, here's a paper that Lucia and I wrote where we do summarize the complexities of this machinery. A few words about the interaction between the LULUCF regulation and other key EU land law and policy areas. I mentioned the CAP, I mentioned the Renewables Directive, and I mentioned the Effort Sharing Directive. Now, in as far as the Renewables Directive is concerned, what you need to know for the purposes of today's class is that the Renewables Directive doesn't only concern biomass. Nevertheless, for some perverse outcome that could not have been predicted arguably at the time of the design of this instrument, EU forest biomass makes up to 60% of all EU domestic biomass, which is a lot. So in other words, the introduction of the existing regime has created incentives to burn more forest biomass. And some countries like Finland obtain most of the renewable energy from the burning of forest biomass. Many scientists had warned that this was not a good idea and that we would see an increase in harvesting of forest biomass as a result of implementation of the Renewables Directive, which is what ended up happening. So we were, in other words, producing a shock in the system that had unpredictable or risky outcomes. And this has ended up to be correct. In as far as the CAP is concerned, the Common Agricultural Policy, it's fair to say that the present CAP has nominally accommodated greater climate change concerns, but in practice has failed to really deliver the tools, the levers to enable farmers to adopt more climate virtuous behavior. Many had hoped that the current CAP would better align with the climate neutrality objectives, but it's fair to say that member states couldn't really quite reach the political compromise needed in order to significantly alter the status quo. This is why, soon after the LULUCF regulation was adopted, some climate change litigation started targeting the measures that I've just mentioned. And I don't have a lot of time to explain to you the technicalities of these two cases, but I wanted to mention two of these climate lawsuits brought before the European Union courts. The first was the People's Climate case that asked the Court of Justice of the EU to set aside 3 instruments that were integral part of the EU climate package for 2020-2030. Amongst these, as you can see, was the LULUCF regulation. The applicants were not pleased with the way in which this sector was regulated and contested the ecological integrity of a number of its provisions. The second case is the EU biomass legal case. A bit of a mouthful, but basically what the applicants wanted to do was to set aside the Renewables Directive in as far as it provided for the burning of forest biomass as a renewable energy source. And again, these were very ambitious cases, both of them. They have not ended up being heard on the merits by the court because they were set aside at the admissibility stage. What is interesting, however, is to consider how these two lawsuits ended up in a moment when the European Union itself was thinking again about the measures it had just adopted. And this is what has ended up happening with the Green Deal and the European Union, going back already to the drawing board even before the measures that we have mentioned were implemented. So what does the Green Deal say about LULUCF in particular? I'm sure that you all know what the European Green Deal is. It's much more than just the LULUCF sector, but it's important for us to understand what has changed with the Green Deal when we're talking about EU climate policy. The Green Deal aligns the European Union with the net zero goal set out by the Paris Agreement. So it outlines a series of measures that the EU should adopt or will adopt, and is in process of adopting in order to get there. What is important for us to understand is that there is a number of ways in which you can get to net zero. And the pathway that is identified with the Green Deal is one that relies significantly on the land use sector. So I don't know if you can follow me here, but with the LULUCF regulation in 2018, the land use sector had already been given a more prominent role in the past, but in a fairly conservative way. The Green Deal pushes the EU even further in terms of reliance on the land use sector in order to get to net zero. Again, I don't want to overburden you with technicalities, but here there is a net emission target, which is different compared in terms of quality, is different compared with the 2020 target. And the achievement of this net emission target requires nature-based solutions in a more ambitious and aggressive way than in the past. So the LULUCF sector really plays an important role in the architecture designed by the Green Deal. And here's where, once the political course of direction was set by the new European Commission, when the Sherpas, the civil servants, had to find ways in order to make it happen. A number of options were discussed, and you see them summarized on the slide. There was an internal dimension to this conversation, as well as an external dimension. And both of these line of action required reform. Required reform of existing EU law instruments, including the LULUCF regulation. So the Commission identified a number of policy tools and legal tools that needed to be activated or reformed in order to make the objectives of the Green Deal achievable. And amongst others, this included the review of the LULUCF regulation and of the Renewables Directive. Now, the LULUCF regulations reform is still work in progress. I would like to say to you that it's almost done. I've said this before, And it's really almost done now because the final text of the revised LULUCF regulation is meant to be published in a few weeks, hopefully. Because of the political sensitivity of the area, there has been a lot of back and forth, but the Commission published its proposal in 2020. And what the Commission set out to do was really to continue with the status quo and the existing LULUCF regulation up until 2025, and from then start changing the way in which the sector is regulated. By doing what? By giving member states targets to meet in the LULUCF sector. First time ever. You probably know, if you studied EU climate change law before, that targets have been used in the past, for example, for renewable energy deployment in member states. Mandatory targets, penalties if member states don't meet these targets, and so on. Whereas in the LULUCF sector, this is the first time this is happening. So big novelty. The European Commission also suggested that the sector should reach climate neutrality by 2035, which is soon, very soon. So there's been a lot of back and forth on these propositions from the Commission, and the final outcome of this conversation will be revealed to us all in the coming weeks. In the meantime, the EU has struck a deal on the Renewables Directive reform. And as you can see from the quote that I put in the slide, sadly, the EU has not revised significantly its approach to biomass for the present decade. This has disappointed those like the proponents of the EU legal biomass complaint that have really not been heard. And this is a problem because data from member states of the EU that have an important forest sector is showing us that things with the existing rules are not going very well. Again, I don't want to overburden you with the details because this is highly technical, but earlier this year, Finnish-based NGOs with support of some of my colleagues at the center at the University of Eastern Finland launched the first ever climate lawsuit in Finland that specifically concerns the management of the forest carbon sink, because ostensibly complying with the rules, apparently, Finland has managed to accrue an enormous hole in its carbon sink, which means that all the assumptions upon which its plans to achieve carbon neutrality by 2035 have been scuppered. Of course, the lawsuit is not necessarily about the hole in the carbon sink, but rather about the process and the legal process concerning the adoption of measures, concerning the hole in the sink and how to remedy that. But what is interesting for us to reflect on is that Finland is not alone, sadly. Other countries have experienced over-harvesting, partially due possibly to the implementation of the Renewables Directive, possibly due to the energy crisis and the fact that forest biomass has become more attractive as an energy source, regardless of carbon concerns. But what is evident is that there is scope to reform the rules, and that maybe the reforms that we are seeing going through the Parliament and the Council right now are not even enough to address the shortcomings in the rules. Which leads me to some interim conclusions, because it's not possible to draw final conclusions on what I'm talking to you about today, I'm afraid. The EU has, with the LULUCF regulation and the other policy tools that I mentioned today, ventured into unknown territory, uncharted territory. The rules that were developed in recent years are clearly an incremental improvement compared with the past, where there was a largely tacit consensus on leaving the sector alone. It's fair to say that some of the measures that have been adopted in recent years have been contentious, especially the so-called flexibility mechanisms. It's also fair to say that opportunities have been missed in addressing the overlaps between, for example, LULUCF regulation and the CAP, LULUCF regulation and the Renewables Directive. There is a lot of loopholes there, and new better rules need to be devised in order for things like that has happened in Finland not to happen. So the big question that we're all waiting to answer is, will the Green Deal reforms tackle these problems? But better, because we don't really want to follow suit and do what Finland is trying to do now, which is to reconsider its plans. Of course, there have just been elections in the country, so that they have bigger, even bigger problems now in terms of defining what their pathway towards climate neutrality might be, because there is an internal debate on whether or not even to get to climate neutrality by 2035 now. But the question really is, imagine if what has happened in Finland would happen at the EU scale and our assumptions on the forest sink turned out to be misplaced. That means readjusting our plans towards carbon neutrality, climate neutrality, and this would really be quite a disaster. So we cannot but hope that the rules that are being adopted are better, but we also need to be keeping our eyes peeled to see what's coming next, because the story is not finishing here. And I'm sure that if you are interested, you will have plenty to study and write if you are interested in doing some work in this area. So I thank you very much for listening, and I will very much like to hear any questions you may want to ask. Thank you.